Final case we'll hear this morning is Riverbrook versus Fabode. This is also a 15-minute mini oral argument on the application. Mr. Tomkawiak, that means you may try to reserve some of your time, and you'll have 2 minutes when we won't interrupt you.
Thank you. Good morning, Chief Justice, Your Honors, and may it please the Court. Steve Tomkawiak, pleased to be here on behalf of the defendant, appellant, Abimbola, Fabode, caller Abby, and other occupants. The Court appropriately ordered supplemental briefing and MMOA to consider guidance to the 3 courts below. All had difficulty determining the status for evaluating disability certification, as well as to housing providers and residents throughout the state with disabilities, and just to determine the standard for disability certifications. Just in the proper context, this is a fair housing case. It involves someone's private home. This was a mobile home. An interior home person has great rights when it comes to emotional support animals, service animals, and such. In place of public accommodation that are subject to the ADA, you consider the rights of the public. And so there is no right to an emotional support animal in ADA settings. There's no broad right to service animals that's restricted to dogs and miniature horses. So this is purely a Fair Housing Act case where broad rights should be construed in favor of the person with the disability. I request that this court reverse the Court of Appeals, vacate that published decision. You can see it's unworkable. Remand this case to the district court for further proceeding consistent with HUD's 2020 Assistance to Animals guidance. First, the 2020 guidance is already accepted within the housing industry. It's nationwide policy by HUD. It answers all questions concerning assistance to animals. The housing industry, I cited in Appendix 31, the leading largest rental property owners association, they follow it. It's cited by courts. It's used in consent judgments, conciliations, HUD, Michigan Department of Civil Rights. It is the standard that's being used. HUD had a March 2022 conference, nationwide conference, dealing with, I'll quote, assistance to animals are not pets, reasonable accommodations related to support animals. Yes.
Let me ask you a question that might not have the greatest legal significance, but it's always been in my head. I need to clear it out, okay? We wouldn't be here today if the breed of the dog wasn't prohibited by the lease, correct? The tenant claimed it's a Labrador Retriever mix. The landlord believed it to be a Pit Bull mix. Since we're here, is it fair to say it is a Pit Bull mix?
Well, on the record, the only record shows Labrador Retriever mix. If you look closely, that's the only thing that's said.
Okay.
So
initially,
that was not squarely resolved by the district court.
All right.
Let's assume it's a Pit Bull mix.
Okay. Initially, the tenant submitted paperwork from a vet declaring that the dog to be an emotional support dog. Is there any recognized veterinary certification for emotional support dogs that come from vets?
No, it's not required.
Okay.
There's no certification for it.
All right, so the client then went and sought certification over the internet. Is it true that the website for United Support Animals states that it, quote, promised a letter to support an applicant's request for an emotional support animal for $179.99?
Yeah, I'm not disputing what the website says.
Okay. This United Support Animals referred defendant to Ms. Vanette. Is that how they came together, correct?
That's my understanding.
And after a single brief phone call, Vanette determined that Anthony was in need of an emotional support animal. Is that fair to say?
No.
Did she call him in and have a consultation or establish any sort of a professional relationship of any sort of medical or quasi-medical in nature at all?
Yes.
So they saw each other personally? It was more than a phone call?
I believe there were
Before
3
she
phone
issued
calls.
the certificate?
The Court of Appeals referenced the resident disability certification form on the first page. The Court of Appeals did not mention the second page, which said that she did, over the phone, telehealth on 3 occasions, May 31st, June 12th, and July 24th. There were 3 conferences, discussions, sessions between the 2, not
Okay.
one.
Right, she then took the position that she need not meet the patient in order to make a diagnosis, correct?
You mean by meet, you mean in person?
Correct.
Correct.
Correct. She used the word diagnosis, though, correct?
Correct.
And the Court of Appeals sent it back for some determination of an expert qualification. Isn't that fair if she's diagnosing something? I mean, how I'm an average layperson. I don't know when an emotional support animal is needed or not needed. Shouldn't we just stick with the Court of Appeals and let them go down and do a 702 analysis?
Absolutely not.
Why not?
Well, first, 3 weeks ago, Michigan House passed Senate Bill 5751. 108 to 0 was a vote on that. And it covers the issues in this case. First, it defined the length of service. It says have to have a 30-day patient-provider relationship. Here, the record is 57 days if we, use the date from the first and last conference that they had. There's no expert witness requirement. The bill defines Section 3BIV, defines who is qualified to give that.
I don't disagree that there's no expert witness requirement, but inasmuch as she's claiming to have made a diagnosis, isn't that at least an instance where the court should go down and make a determination whether she's even qualified to make a diagnosis?
No, this is a treating physician. If she's in the role of a treating physician, that's a non-expert.
Okay. You rely heavily on the HUD 2020 Assistance Animal Guidance. This guidance sets forth best practices for complying with the FHA, which has provisions similar to our Persons with Disabilities Civil Rights Act, right?
Correct.
And when assessing a request for reasonable accommodation to keep service animals, it does provide us some indication of what the best practices are for making a determination whether this is necessary, right? That they use actually the term best practice.
Yes, best practice said a couple times during that guidance.
But does that mean that that's what they must do, or is there such things as good practice? Why is best practice what is required under the law when they come up with a guideline?
No, it's guidance. It's not a regulation. It's not a rulemaking or adjudication, that type of a thing.
But even sticking with the best practices as defined by HUD, I read it and it says, quote, in HUD's experience, such documentation obtained through the internet is not by itself sufficient to reliably establish that an individual has a non-observable disability or disability-related need for an assistance animal. Here, I guess we have one step more. We have the net talking with Anthony, right? Yes. But is that enough? Is that enough when there's this guarantee from the United, whatever it was, whatever that organization was, that essentially guarantees if you contact us and pay the fee, we're going to get you what you need?
Well, that's why I think the guidance is so helpful, because it informs if deference is given to it, it instructs the community with people with disabilities that just going online to one of those sites won't be sufficient. You have to have a type of relationship, mental health provider-patient relationship. The internet certification alone is insufficient. Really, if you look at the guidance, the first 15 pages, there's only barely over 2 pages dealing with guidance to persons with disabilities seeking assistance animals, but the first 15 pages are all addressing the rights and what housing providers can do, what kind of information it gives them. Hey, you can ask for more. If this was in front of the district court, this came, again, after the district court hearing, this came out afterwards. But the district court could have looked at this, well, you know what, we can go quite a bit further in terms of examining what took place between Ms. Vinay and Anthony Fabode.
I mean, the bottom line for me, it kind of reminds me of the internet industry for certifying someone who wants to be a pastor of an unknown religion so they can officiate a wedding of a friend or a loved one. Clearly, those people are gaming the system. Is there not ample evidence in this case for the landlord to reasonably have concluded that there's a little gaming of the system here, and didn't the lower courts essentially cut them off and say, look, I'm stuck. If there's any documentation at all, I have to accept it?
Well, this is, there's no record developed. There's no testimony. There's no indication as to what kind of disability Anthony Fabode had. This is not, there's no real record in terms of what occurred. The district court did take the view, if we have a letter, that suffices, and that's obviously not correct, right?
So you concede that's not enough. The district court has some
no
ability
argument about that.
To evaluate the quality of that.
Correct.
Okay.
But here's the problem. I like the way that Michigan Department of Civil Rights and MDCR put it, that to overcorrect, basically the Court of Appeals overcorrected. We got a problem with, tenants not being able to afford attorneys. We know that. People with disabilities, even less, they have lower income. How in the world are they going to get a certification that's going to survive a rigorous Daubert analysis under MRE 702? And it's kind of like looking like the opinions written to attorneys, but it's supposed to be something that guides the housing industry. People need guidance in terms of how do you assess these certifications? How do you assess requests for emotional support and service animals? 702 is not the mechanism to do it. It's novel, it's different, it hangs out there like, it's problematic in a lot of ways. It basically cuts off rights. There's no way a small minority would be able to purchase or hire an expert that would meet that standard.
I understand your concern, and it's a very legitimate one. But 702 is simply a rule that says when there is testimony needed that is beyond the scope of the common understanding of the everyday person, expert testimony is necessary. And expert testimony is only permissible if you can meet the requirements of 702, right? With some sort of hearing, whether it's a full-blown Daubert hearing or something less that simply looks at someone's qualifications and say you're sufficient to testify. Fair enough?
That's an absolutely correct statement.
And isn't it beyond the scope of the average person for me to make a determination? Yeah, you need an emotional support animal or you don't.
And that's where the problem comes in. It's not. HUD's guidance makes that clear. Cases have made it clear. Certifications, those are fact issues.
The guidance can't tell courts how to apply rules of evidence.
Well, if they want to pull rule of evidence, 701, lay opinion testimony. I mean, there's rule of evidence if you want to do it. But no court has imposed an expert witness requirement on disability certifications. It's just not the standard.
You agree that a remand is necessary. It's just the scope of the remand, correct?
Correct.
Okay. And you would have it sent back for what?
For giving deference following giving deference to HUD's 2020 policy, assistance animal guidance.
But
Yes.
have we ever established, certainly a landlord is allowed to probe into the accommodation request to get more details as to why the accommodation request is needed without necessarily revealing the disability. I'm applying in the employment law world. Employers do this all the time. It's an interactive process without a lawyer a lot of the time. So I give you that. And without experts, usually there's some history that can be demonstrated to show the need for the accommodation. So, in this case, I recognize the record wasn't really developed. It was, prematurely probably shut down to get into that. But you would acknowledge that they can probe more on the reason the accommodation was needed?
Absolutely.
Okay.
Absolutely. There's no denying
Would
that.
you mentioned the, I think it was House bill?
Yes.
And that provision, or there is a provision that says that a healthcare provider shall not receive a fee or any other form of compensation solely in exchange for certifying a person with a disability's need for an emotional support animal. A certification issued by a healthcare provider who receives compensation solely for providing the certification is invalid. So that, again, on remand, that question of whether or not, the website representation that promised a doctor's letter for $179.99 may be an issue to be ferreted out below?
Correct. All of that can be considered.
Okay.
But Justice Welch had the correct approach. The goal ultimately is to avoid litigating these things. Turning it into turning disability certifications into Daubert proceedings, it's not the guidance that's needed within the housing industry. And then we're talking about property management companies, resident managers, co-op boards, condominium boards. They're all involved in considering this, as well as people with disabilities. So we want plain English, kind of approach to do it.
Counsel, you're almost out of time. I just wanted to clarify the facts so I understand them. And I understand your point about, an expert testimony not being required, although if it's presented, it seems to me the court has to evaluate it as such. But leaving that aside, the counselor testified, I guess, at the district court hearing, at least according to the Court of Appeals, and she said that she determined his need for the support animal after a single brief phone call. You're saying that's not what she testified to?
I'm saying her certification form, the certification form that she prepared lists 3 times that she conferred with Mr. Fabode.
It says here, she reviewed no prior medical records, conducted no diagnostic testing, and provided no counseling to Anthony. Do you agree with those facts?
I can't, I wasn't, I didn't handle the hearing, but that was her testimony. The House bill addresses what's
Well, I mean,
required in terms of reviewing medical
Listen,
documentation.
that's a great public policy for the future, but it doesn't apply to this case, right? I'm just trying to figure out what to do with this case, and how to understand it, because as Justice Zara pointed out, the HUD guidance seems to identify this as a common problem. It says before the passage that he noted, some websites sell certificates, registrations, and licensing documents for assistance animals to anyone who answers certain questions or participates in a short interview and pays a fee. Seems like that guidance was designed for this case. Am I wrong?
And it's included, I think, in the new statute.
And again,
Something similar.
we're dealing with, it's hard to, go into detail with the facts because we don't have a developed record. We don't have any testimony from Mr. Anthony
Well, we had
Fabode
the
about his
testimony
disability.
from the treatment provider. We had the testimony from the treatment
We did.
provider.
But obviously, an obvious question is, will you say it one time and then the redirect, well, there is no direct, but the redirect would be, well, let's go look at your certification form. That's Exhibit 8 to their response to application for leave to appeal. You wrote down on there, you met with him on 3 occasions. Is that correct? And how long were those? And what are the phone records? And, what kind of things were discussed?
Is it fair to say that while in this particular case or this particular certification may not ultimately prevail, or a decision on that may not ultimately prevail in that case, the problem that you have as a bigger picture is you have a published Court of Appeals opinion that says that it has to be 702 analysis.
Yes, and that applies to any kind of, it would apply across the board to disability determinations, whether it's reasonable accommodation, reasonable modifications, or just any kind of a disability certification. It looks like the 402 expert witness hammer can be struck against every case. It's going to breed litigation.
Okay, thank you.
Thank you.
Thank you, counsel.
Madam Chief Justice, members of the court, may it please this honorable court, my name is I. Matthew Miller, and I am here on behalf of the landlord, Riverbrook. Just to address some of the things that were brought up in the prior discussion. I don't believe that the Court of Appeals opinion says that every time there's one of these cases, there has to be an expert. In fact, I believe the exact opposite. I don't believe an expert's ever necessary if you have an actual treater who can testify to actual facts, and that's the problem with this case. I don't understand how anybody in this room can actually believe, and that includes counsel and everybody else, that Anne Vinay's letter was based on facts and an actual treatment. It's a letter written as a form letter, clearly, as Justice Zara explained, to get an emotional support animal. If you Google emotional support animals, you'll get pages and pages and pages of companies that are doing this exact same thing. And if you reviewed the amicus brief filed by the Property Management Association of Michigan, full disclosure, I'm the legislative chair of that body, and we actually were behind the drafting of the bill that passed unanimously in the House, and also behind the bill that passed the House and the Senate 2 years ago, which the governor vetoed. Be that as it may, this is a big issue. And if you look at the amicus brief, Anne Vinay wrote 17 letters that are attached to that amicus brief that are virtually identical to the letter written in this case. She met with, if you want to call having a momentary phone call, with the occupant on the same day she wrote the letter. Whether there were subsequent conversations thereafter was not fleshed out at the hearing, that's true, but she testified at the hearing that she was not a licensed counselor, she did not perform any objective testing, she did not review any medical records, it was beyond the scope of her practice, actually, to provide, to do objective testing. She doesn't have the ability to make a diagnosis. If she were an actual treater, assuming she had the authority to treat anybody, which she doesn't, she would be a fact witness. And frankly, all the cases that are cited in appellant's brief related to this were all people who were actual treaters. And if she were an actual treater, she would be able to testify to actual relationship and actual treatment, but she's not. If that were the case, we would not be here today. But Ms. Vinay testified to her completely unfounded opinion. It was based on absolutely nothing.
Look, I'm with you. I understand your argument completely. Let me just ask, specific to this case,
Yeah.
your legal obligation is to provide a reasonable accommodation. Why not just get this dog checked out and determine whether it's a pit bull breed or not? Because as I understand it, your lease would let any other kind of dog in, but just not a pit bull breed. Is that accurate?
We entered a consent judgment with the defendant at court, which they agreed they were going to get rid of the animal. That was the agreement that we made. And then subsequently, they went to U.S. support animals and said, aha, it's not a pet anymore. Now it's a emotional support animal. And when the dog was still there after they promised to remove it, that's when we sought our order of eviction, and they filed a motion to stay the order of eviction.
Your consent judgment does not preclude another animal, just right? Or is it the lease that precludes pit bull breeds?
No, the lease precludes certain breeds. The consent judgment was an agreement between the parties that they were going to get rid of the animal. That's what was violated. They didn't get rid of the animal. We never litigated that
Was
issue.
it done with the notion that they'll get some other animal that doesn't violate the lease?
I don't know if there was an indication as to whether they were going to get a
So-
new animal.
All right.
Help me, I understand your position, and maybe, you're gonna win this case 10 ways from Sunday, any way you look at it, whether it's because of the consent decree or because of all this. What do we do with the fact that there's a published Court of Appeals opinion that arguably, and I would love to hear differently, suggests that these requests are subject to a 702 analysis? Tell me why this opinion, published opinion, isn't going to potentially wreak havoc on, or impose an unfair burden on people trying to submit requests in other cases for
Absolutely.
accommodation.
Because, as I said before, she was not the treater. If, in fact, there was a real treater relationship, a real treater wouldn't be testifying to opinion. She admitted at the district court that this was her opinion that she was testifying to. So a real treater, if God forbid, Your Honor, you had some type of a disability, presumably you would have had a relationship with some type of a counselor, physician, psychiatrist, psychologist for more than the same day you got your emotional support animal letter.
So you're saying that the Court of Appeals saying that that the analysis required is a full 702 analysis is based on its holding that she wasn't a treater?
Yes, it's based on the fact that.
So in another case where it is a treater, or more legitimate treater, arguably, then this case doesn't require that 702.
That's right.
So it's only going to apply in cases where somebody gets an expert who they don't have a pre-existing relationship with? You're saying that's how the Court of Appeals opinion can be cabined?
That's how I read it. I read it that they said that Ann Vinay came to the district court and testified on an opinion that wasn't based on anything, that she hadn't reviewed any documentation, hadn't seen a medical record, had written a letter that said Anthony has been diagnosed with a differential illness, has been diagnosed. By whom? She didn't diagnose him. That's not what her letter. Her letter doesn't say, I diagnosed Anthony with a differential illness. It said, he has been diagnosed. If that's true, which we highly dispute, if that's true, somebody theoretically diagnosed him. And perhaps that person, who frankly doesn't exist in my opinion, but let's say they did, that doctor, psychologist, psychiatrist, who's authorized to make a diagnosis, which this person is not authorized to make, would then be able to come to court and testify and say, oh yes, I've been treating Mr. Fabode for 6 years. Oh yes, he has an emotional disability. Absolutely, he needs this animal in order to live and use this home. Great. We wouldn't even be in court if a landlord got information like that. But as you'll read in the amicus brief from the Property Management Association, the people who testified in their affidavits there explain how they're receiving dozens of these letters from the internet all the time from people just like Anne Vinay. And in fact, Anne Vinay herself, over and over and over again, writing letters that are based on absolutely nothing, that make these, excuse me, declarations of diagnoses of vague disabilities, even if it is a disability. And don't forget, in this particular case, at the first district court hearing, and the transcripts are attached to my brief, if at the first district court hearing, Mr. Fabode, the occupant, said multiple times, the dog is not there. The dog is not there, meaning not living in his home at the time. The whole point of this is that he has to have this dog in order to live and use and enjoy the residence. He is shouting from council's tables, the dog is not there, says he doesn't need the animal to live and use the home. He doesn't need the animal at all. It's just simply false. This case is based upon lie upon lie upon lie. And I don't believe that there's actually anybody who believes that Anne Vinay's letter and her supposed explanation of her testimony has any validity at all, which is why this Court of Appeals said, if it's an opinion, which she testified it was.
Counsel, let me ask a couple of questions about the type of evidence that, I wasn't a district court judge and I didn't handle these kinds of hearings. But as I understand it, I looked at some of the HUD guidance. There's, I think, observable disabilities and non-observable disabilities, and there's different evidentiary requirements for each. But there could be lay testimony from the tenants and from other witnesses concerning a disability, right?
Absolutely.
And that wouldn't have to meet the expert witness qualifications.
Certainly not, and there was no such in this case.
And I think what you've already said is if there was a treating physician or a counselor of some sort, that individual could testify or provide other admissible evidence without meeting the expert witness requirements.
Absolutely, Your Honor.
And so I know counsel mentioned the concern about the expense of making the requisite showing, but it seems to me that this individual could have gotten on the stand himself and provided some testimony as to why he believed he needed the support animal. But that didn't happen in this case, right?
Correct. That did not happen.
This whole case rises and falls on the internet letter.
That's right. That's the only evidence that he presented to the court. And I'll note that they didn't participate in any meaningful way at your old.
And he was able to pay for that letter, right? Was it almost $200?
I don't know how much he paid, but it was $179 or $99. The prices vary and change all the time online. And not that it matters, but when I've testified in the legislature about this on numerous occasions, members of the committee have all gone online to get an animal. Like Carlene Lehman in the Property Management Association got Anne Vinay to write a letter about herself under a pseudonym that reflected that she was 1 year old and had a cat that was 19 years old. That's one of the letters that's attached to that brief. It just is pervasive.
If I agree with you, it's the way that Justice Viviano summarized it of, trying to characterize the different evidence that may be amenable. Can you show me, I'm struggling still to read the Court of Appeals opinion as making that distinction that Justice Viviano has made, which I think is probably correct. I'm a little less confident in future cases or future courts being able to cabin what the Court of Appeals said. It doesn't say, well, because it was this particular evidence by Vinay. It was saying Fabode as the proponent, bore the burden of proving that they have a handicap and require an accommodation. Here's the evidence that was presented. 702 governs the admissibility of the evidence, and the lower courts abdicated their responsibility to evaluate it under 702. Because
she was not the treater and she was testifying to her opinion, and there was no other evidence presented to support the existence of a disability. Justice Viviano is right.
Just to be a little more precise, the opinion says the only evidence presented by the Fabodes was the letter authored by Vinette.
That's right. There was no other evidence presented.
And then the rest of the analysis proceeds from there, what has to be done with respect to an internet letter. I'm just trying to think in my mind, is there some scenario in which an internet letter of this sort, based on, let's just call it relatively flimsy, interaction between the person providing the letter and the person receiving it would be considered lay evidence? I mean, I guess you could have lay evidence surrounding the receipt of the letter, but
I mean, I don't know how a person who talks on the phone for 1 minute or a few minutes could ever be considered somebody who could provide an actual basis for a disability.
Doesn't though the House bill and other things specifically provide for telehealth visits?
Oh, absolutely, absolutely, telehealth is legitimate.
So it could be a letter from somebody who had only telehealth visits, and let's assume they meet the other things, right? But
Yes.
you're, again, because it says the only evidence presented was Vinay's letter, you think that is sufficient to say only in this sort of identical factual situation, in a published opinion, that's only, the only time that 702 is required?
Yes, because if in fact Mr. Fabode had been treating with Ms. Vinay for weeks or months and had been, and she was authorized, which, remember, she's not authorized to make a diagnosis. That's not within her purview as a limited license and now unlicensed limited license professional counselor. She can't do that. But assume she was a psychiatrist, and he was meeting with a psychiatrist for a few months to delve into his emotional disability. And that physician said, you know what, you need this dog in order to live in your house. Now, theoretically, Fabode should say, you know, I'm having trouble, I have this emotional issue, I can't live in my house, is there anything I can do? You know, the treatment of an emotional disability, the first treatment shouldn't be, go get a dog. I mean, that's the other part of the problem too. Ms. Vinay was asked at the hearing, what suggestions did you make for other treatment? Did you refer him to other treatment? And her answer was, that's outside of the scope of my practice. I can't refer him for other treatment. So what is she doing there? What is she doing other than writing a letter because she was paid to do it? As you noted in the bill, if that law were to become law, you would not be able to write a letter and receive payment solely for that. Now, you could receive payment as a treating doctor. I went to my primary care physician.
Let me just ask, it seems to be that the sticking point is the question of the 702 requirement in the Court of Appeals opinion, and you say it's not always going to be there. But what if we read it as it is? Can't we get past that as well? When a treating physician, a recognized MD, osteopath, someone with mental health certification provides an opinion, it might still be an expert opinion, but it's an easy hurdle over 702, right? The problem here is that Vinay has this contradictory testimony. I'm not qualified to do this. It's based upon an internet solicitation and a phone call or two. I'll give them the benefit of the doubt. And then every letter's the same. It seems to be a form letter that calls into question the legitimacy of this person who's opining on something that the everyday person can't really recognize, i.e., do you need an emotional support animal? So couldn't it be that even if the Court of Appeals opinion is read as requiring 702 analysis across the board, in most instances it's going to be pretty easy to get there. It's the specific facts of this case that makes it problematic.
I mean, you couldn't have said it any better. I mean, you have a clearly fraudulent letter written by a total stranger that's being presented as though it were fact, and a doctor or a psychiatrist or a DO or whomever would be able to come to court as a fact witness, or if they wanted to be considered as an expert, they would be able to say, I have this expertise, I have treated this person, I've reviewed the medical records, I can see that they have an emotional disability, and I know that they need this animal in order to live in this home. That's exactly right. And so with that, unless there's other questions, my time has expired. I'd ask the court to just deny leave to appeal and leave the Court of Appeals opinion to proceed by itself.
Thank you, counsel.
Thank you all so
Used up all of
much.
your time. The case will be submitted. We will return to the bench at 12:40 for the afternoon session.